Seconds to go. Start. This appeal challenges the judgment and order dated 17th October 2022 passed by the learned single judge of the High Court of Judicature at Bombay bench at Aurangabad in criminal writ petition number 246 of 2021, by which the learned single judge dismissed the writ petition preferred by the present appellants. The writ petition had been filed with the prayer to quash the order dated 24th December 2020 passed by the learned Assistant Sessions Judge Sangmar, District Ahmednagar, wherein the learned Assistant Sessions Judge had rejected the application preferred by the appellants seeking discharge from the charges punishable under sections 306 and 34 of the Indian Penal Code 1860 pending against the appellants before the court of the Assistant Sessions Judge Sangmar in Sessions Case number 75 of 2015. The facts which lead to the present appeal are as under. On 20th March 2015, the police station Ashvi, District Ahmednagar received an accidental death report by one Vikas Bahu Sahib, who stated that on the same day at about 10 am, his sister Jyoti Nagare, aged about 25 years, had committed suicide by hanging herself from the iron pipe situated in the bathroom of her paternal house, where she had been residing for the past 2 years. Subsequently, on 25th March 2015, Mrs. Sindhu Bhai Bhau Sahib, respondent number 2, mother of the deceased, lodged a complaint at the said police station. According to the complaint, the deceased had been married to Prakash, appellant number 1, on 19th November 2009, after which she had given birth to twin sons. After marriage, disputes arose between the deceased and her husband and in-laws from time to time, with the complainant alleging that the deceased had been mentally and physically tortured at her matrimonial house. However, on the intervention of the complainant and her family, the disputes were patched up and the deceased was sent back to her matrimonial home. Soon thereafter, owing to persisting acrimony at her matrimonial home, the deceased and appellant number 1 started residing separately away from the matrimonial home in Pune. It was further alleged that on 8th August 2013, appellant number 1 had physically abused the deceased over a demand of rupees 20 lakhs for the purchase of a new plot of land. After this incident, the deceased came to reside at her paternal house. Subsequently, a criminal case being Criminal MA number 175 of 2013 came to be filed before the Court of Judicial Magistrate First Class Sangmar against the husband and in-laws of the deceased under sections 12, 18, 20 and 22 of the Protection of Women from Domestic Violence Act 2005. During the pendency of the criminal case, a Mahalok Adalat was held in the court of Sangmar on 17th February 2015, which was attended by the complainant, the deceased, and the present appellants, among others. The complainant, respondent number 2, alleged that on the said day, the present appellants told the deceased that they were not ready to reach a compromise in the matter, and further that she would not be allowed to go back to her matrimonial house. The deceased was further advised by appellant number 1 to remarry, as he would not accept her or her children at the matrimonial house. Subsequent to this incident, the deceased would frequently say that she would commit suicide as her life no longer held any meaning. Thereafter, on 20th March 2015, the deceased committed suicide by hanging herself from an iron pipe with the aid of a sari. On the basis of the complaint, a first information report being crime number 12 of 2015 was lodged under sections 306 and 34 of the IPC against Prakash, appellant number 1, Pandurang, appellant number 2, the father-in-law of the deceased, and Pradeep, appellant number 3, the brother-in-law of the deceased, at the aforementioned police station. Upon completion of the investigation, the charge sheet came to be filed on 28 September 2015. Being aggrieved thereby, the appellants filed an application under Section 227 of the Code of Criminal Procedure 1973 before the trial court, praying to be discharged from the said case. The trial court, by its order dated 24th December 2020, rejected the aforesaid application on the ground that there was sufficient ground to proceed against the appellants. Being aggrieved further, the appellants preferred a criminal writ petition before the High Court for setting aside of the aforesaid order of the trial court. The High Court, void the impugned judgment and order, dismissed the writ petition, finding it to be devoid of merit. Being aggrieved thereby, this present appeal. This court, while issuing notice on 30th January 2023, had stayed the criminal proceedings, being Sessions Case number 75 of 2015, pending before the trial court until further orders. We have here Mr. Nitin, Learned Counsel, appearing for the appellants, and Mr. Aditya, Learned Counsel, and Mr. Siddharth, Learned Counsel, appearing on behalf of the respondent State of Maharashtra. Mr. Gavade, Learned Counsel, submitted that there was a delay of 5 days in lodging the FIR. He submitted that although an accidental death report had been filed on the day of the incident by the brother of the deceased, there is not a whisper about any harassment caused by the appellants to the deceased. It also did not disclose any involvement of or instigation by the appellants which might have led the deceased to commit suicide. He further submitted that the FIR was an afterthought and no satisfactory explanation has been offered to justify the inordinate delay. Mr. Gavade further submitted that it is not a case of prosecution that the appellants spoke in such a manner which would amount to abatement of suicide. He further submitted that the appellants met the deceased only on the day of the Mahalok Adalat, which was held on 17th February 2014, where appellant number 1 is alleged to have told her that he did not wish to cohabitate with the deceased any longer and he did not wish to settle the proceedings initiated by her, merely because the deceased was depressed about her situation. It would not be enough to convict the appellants, particularly since prima facie the ingredients of Section 306 IPC are not fulfilled. Mr. Gavade submitted that the deceased had been residing separately from the appellants since 8 August 2013. In the intervening period between the date of separation and the date of the incident, the appellants had interacted with the deceased only on one occasion, that is, on the date of the Mahalok Adalat, which was held on 17th February 2014. He submitted that the FIR wrongly mentions the date of the Mahalok Adalat to be 17th February 2015. It is submitted that the deceased committed suicide after over a year had passed. However, the courts below did not consider this aspect or look into the Rojnama of court proceedings, which clearly showed the date on which the Mahalok Adalat had been held. Therefore, he submitted that in view of the time gap between the alleged meeting and the date of suicide, there is no immediate instigation or abetment to commit suicide which can be attributed to the appellants. Stop.